As you can see, I look much better now than I did then. I have this lovely mustache, and yeah, I need a new picture of these. Yeah, good morning, everyone. And to echo what the others have said, lovely to see so many people here today in spite of demonstrations and strikes and so on. And also, I understand that there are more people even online. So great to see so much interest in the EEA on this anniversary. Yes, my name is Ole Dahl Valtýsson, as Ásdís mentioned, and I am going to underline attempt, to essentially explain how EU law becomes EEA law in only 10 minutes. We are on time, right? Yeah. Okay. But this is only a short introduction just to give you a taste of it. But there is a very exciting breakout session in the afternoon where I will go deeper into this with my colleagues. So sign up if you haven't already done so. Yes, so first to start with the context. Why? No, wait, that's the one. Why are we talking about this? Why does EU law become EEA law? And as Marit mentioned, the answer is homogeneity. It is the main principle of the EEA that the European Economic Area is based on the same rules. And one could categorize this concept a bit further and view homogeneity from different angles. First, the judicial dimension, that the rules should be uniformly interpreted and applied. And secondly, a surveillance dimension, that the rules should be uniformly enforced. And thirdly, a dynamic dimension stemming from Article 102 of the EEA agreement, essentially that there are constant updates to the EEA agreement, and EU law is constantly being made into EEA law, so to speak. So this was very shortly on the why. This is on to the what. What kind of EU law becomes EEA law? Well, only EEA relevant EU legislation. And what is EEA relevant? Well, it's the EU law that falls under the scope of the EEA agreement. And as Marit mentioned, this is the essence of the internal market, the four freedoms of goods, services, capital, and persons. Also competition and state aid rules, and what we often refer to as flanking and horizontal policies, which include close cooperation in the field of environmental and social policy, for example, but not the common agricultural policies, not the EU customs union or the EU trade policy, for example. This is outside the scope and therefore not EEA relevant. So now I've briefly mentioned the why and the what. And here we have how it is done, essentially. And this is the incorporation procedure in just one slide. For those not attending the exciting afternoon session, you need to listen carefully now. So first of all, the EU side adopts the acts. Before that stage, there is another stage on decision shaping. Again, I don't have much time to go into that, but there is a specific and again, very exciting session on that in the afternoon. Secondly, the EFTA Secretariat and the EEA-EFTA state assess the EU acts. This includes looking into whether the EU act is EEA relevant, which is what I already mentioned. And this assessment also includes looking into whether there are any challenges in the EU act that would require the need for adaptations. Again, I don't have time to go deep into this now, but for more exciting information, afternoon sessions. I'm just plugging those sessions. That's what I'm doing here. Thirdly, we have the drafting stage. This is where the EFTA Secretariat makes a draft decision for the EEA Joint Committee, which contains the EU Act in question and possible adaptations to the Act to fit it into the EEA agreement. It is then at this stage approved by the EEA-EFTA states and submitted to the EU side. And there can, of course, be some ping pong between the EFTA side and the EU side at this stage until a final text is agreed upon. And then the fourth and final step, the decisions are adopted by the EEA Joint Committee, which meets around 8 times per year. So this means that when we have EU law that is relevant to the internal market, it is not a part of the EEA agreement until both the EFTA side and the EU side have agreed on it. And there is a mention there at the bottom of the slide, constitutional requirements. This part is a bit technical, but very important, so please bear with me. So the usual entry into force clause states that the decisions will enter into force the day after adoption. However, the EEA agreement says that the EEA states may notify to the other contracting parties, the EU side, that a decision can only be binding once so-called constitutional requirements have been fulfilled. This is when the act in question calls for legislative changes in the relevant EEA state. So the EEA Joint Committee has the competence to adopt decisions, but the EEA states have the right to notify that a decision cannot enter into force until constitutional requirements have been fulfilled. Or to put it differently, the decision will not enter into force until the necessary legislative changes have been made in the EEA state. That was probably the most nerdy part of this small presentation, but very exciting. So now we have covered the why. Why are we doing this? Homogeneity. We have covered what we are doing, incorporating EEA relevant EU law. We have covered the procedure, how it is done in a nutshell. And now this slide is about who handles the formal decision making. And it is the EEA Joint Committee that takes the decisions, as I mentioned. It consists of the ambassadors of the EEA states and representatives of the Secretariat General of the European Commission. But before the meetings of the Joint Committee take place, the EFTA Standing Committee meets to harmonize the views of the EEA states because they speak with one voice in the Joint Committee. And under the Standing Committee are the 5 subcommittees that Marit already mentioned and the numerous working groups. And I thought it was important to highlight this as well, because these are essentially the people that do all the technical work. We have subcommittees 1 to 4 that Marit mentioned, subcommittee 5 on the horizontal and legal issues, and then the working groups, which consist of experts from the national administrations, from the line ministries and agencies in the member states. And they are responsible for processing all EU legislation to be incorporated into the EEA agreement. Now, before I conclude, I just wanted to briefly mention where to find EEA legal acts. The acts are incorporated into the annexes of the EEA agreement and have then become EEA legal acts. And you can find the status of them on EEA Lex. And I would also like to mention the web tools on how EU law becomes EEA law, which is essentially what I've been saying, but in a clearer way, and how to read EU acts incorporated into the EEA agreement. And both of these web tools are fairly new, and you can look them up online. They're excellent, actually. Yes, that was the introduction from me, and I think I was within the time. Oh, excellent. Thank you very much.